Good afternoon, everybody. We're just going to give folks a minute or two to join our webinar today, and then we'll get started. So thank you for your patience. If you're just joining us, good afternoon. We're just giving everybody another few seconds here to join, let everybody into the Zoom webinar. So we'll get started in just a few seconds here. All right, looks like that's slowing down. So we'll go ahead and get started since we only have an hour this afternoon while people still continue to join us. So good afternoon again. Welcome to our webinar on conducting workplace investigations. My name is Melissa Keene. I'm a senior program manager with the Institute for Local Government and will be your host and moderator this afternoon. So a quick overview of today's webinar. We're just going to do a really quick welcome and introductions, and then we're going to go through some strategies to navigate workplace investigations. And then we will have some time for audience Q&A towards the end, and we will wrap up and adjourn by 1 p.m. So just a quick overview on tech and some housekeeping issues. So you probably noticed that you are muted as an attendee, and you will be muted for the duration of today's webinar. But you are able to ask us questions at any point during the session. So you should see a Q&A box on the bottom of your screen or in your control panel, wherever that is on your screen. And we'll be monitoring that box throughout today's webinar. Answering any tech-related questions and things like that. And then we'll be pulling all of the content-related questions to go through during that moderated Q&A towards the end of the session. So please feel free to type in any questions or challenges you're having during today's webinar, and we'll be keeping track of that. We also are recording, as you probably heard when you jumped in. So we'll be posting the recording of the session and sharing that with all of you who registered in the next few days. Before we jump in, just want to share a little bit of information about ILG in case you aren't familiar with us. So we're a statewide nonprofit that's affiliated with the League of California Cities, the California State Association of Counties, and the California Special Districts Association. So we really work to provide practical and easy to use resources so that you all as local agencies can more effectively implement policies on the ground. So we do that in a number of ways. We do a lot of education and training in this format, but also in person and at conferences and other in-person training opportunities. We also provide technical assistance and capacity building and convening services to local agencies statewide. We do that in four main subject areas. The first is leadership and governance, which is really a foundational component of local agency work. We do those state mandated trainings, and then a lot of trainings and information such as this one around some of the other legal parameters that you all have to navigate within. And then a lot of work in that space around effective councils and boards and how to be a good governance team and work together. In addition to that, we also have programs focused on civics education and workforce, so helping with recruitment and retention challenges, creating a pipeline to public service, things of that nature. We have a program focused on public engagement, so helping local agencies be more strategic and authentic with their outreach and community engagement efforts. And then lastly, sustainable and resilient communities. So recently, a lot of work around housing and land use, but also efforts around climate resilience and best practices in that space. So if you aren't familiar with us, we have a lot of free resources. Definitely check out our website when you have a chance. With that, I'm going to introduce today's presenters and turn it over to them since we do have a pretty quick timeline. So we're joined today by Sally Nguyen and Susan Arduengo, both with Burke, Williams, and Sorensen. They are partners in the labor, employment, and law practice group at the firm. So with that, I'll turn it over to Sally and Susan. Thank you for joining us.
Good afternoon, everyone. My name is Susan Arduengo. I'm a partner in Burke's LA office and a member of the firm's Labor and Employment Law Practice Group. I'm also an Association of Workplace Investigators certificate holder. For those of you who aren't familiar with the Association of Workplace Investigators, AWI, it's the leading organization devoted to workplace investigations. I'm a membership and marketing committee member and also a committee member of the newly launched Public Sector Affinity Group. And I also lead the LA Local Circle. So if you have any interest at all in getting more involved in AWI, definitely reach out to Sally and I after the presentation, and we'd be happy to share our resources with you. Next slide. Oh, we'll go next for Sally.
Well, hello everyone. I'm Sally Nguyen. I'm a partner at the firm. I'm located in the San Jose office, also part of the Labor and Employment Law Group, as well as our firm's workplace practice group. Like Susan, I am an AWI certificate holder. I'm also a member of the AWI seminar committees. I've been involved in several of the AWI's workplace investigations basic seminar series. And in addition to my investigation practice, I regularly advise and counsel employers, a lot of public employers, on a wide range of labor employment matters. Next slide.
Okay, so a brief session overview of what we're going to learn today. First off, why do we conduct workplace investigations? How to respond to a complaint, defining the investigation, which is very critical, how to actually conduct an investigation, my favorite part, top investigation mistakes, and then Sally will go over post-investigation considerations. Next slide. Okay, so we're going to start off with why we conduct workplace investigations. Next slide. So California employers have a legal duty under both state law, so California law, and also federal law to conduct workplace investigations in response to employee complaints of harassment, discrimination, and retaliation. So at the highest level, there's actually a legal duty to investigate when faced with these sorts of complaints. Next slide. So there are many negative consequences for failing to investigate. As we just discussed on the last slide, failing to investigate may be a violation of the law, depending on the type of complaint that's made. In litigation, failure to investigate, it gives the plaintiff's attorneys the opportunity to attack the employer for their failure to investigate. So that's really important to keep in mind. Second, aside from a purely legal perspective, a practice of ignoring employee complaints can have a detrimental effect on workplace culture. And this may result in more mistreatment or misconduct in the workplace, and also a hesitancy for employees to report unlawful conduct. Bear in mind that we want to encourage good faith complaints in the workplace for a number of reasons, one of which it allows employers the opportunity to resolve unfair conduct and resolve matters before they result in lawsuits, right? And aside from that, investigating and correcting misconduct, should it exist, it makes for a better work environment for everyone. Next slide.
So we briefly covered the reasons why employers conduct workplace investigations. In the next few slides, we'll discuss the steps typically taken when an employer first receives a complaint. Next slide. So the first thing you want to know is, what is a complaint? So a complaint can come in different forms. It can be an oral communication or a written communication. Sometimes it can be formal and clear that the employee is making a complaint, but sometimes it's not so clear. So for example, it can be a comment made by an employee when discussing something that is completely unrelated to the complaint. So it is important to first understand what a complaint is and the terminology typically used in an investigation context. So with that said, the complaint is a general statement about poor or unfair treatment in the workplace. We typically use the term complainant to refer to the complaining party, and the term respondent or subject to refer to the individual against whom the complaint is made. So for example, if John goes to his supervisor and states that he believes Mary is treating him unfairly, John would be the complainant and Mary would be the respondent or the subject of the investigation. It's also important to know that a complainant does not need to use any magic words to make a complaint. They don't need to tell you that, I'm being harassed or I'm being discriminated against for it to constitute a complaint. Complaints can also be made anonymously, and these complaints should be treated similarly to those complaints that are not made anonymously. And a complainant does not need to request any specific actions in order for the complaint to be taken seriously or for it to constitute a complaint. Next slide, please. So after you receive a complaint, what do? When do you investigate? So there are several factors an employer should consider when determining if it should investigate a complaint. As Susan covered, generally, if it's something that's unlawful and there is a legal obligation to investigate, such as complaints of harassment, discrimination, or retaliation, then you should complain. And as a general rule, an employer should consider investigating a complaint if the alleged conduct, if found to be true, would constitute a violation of the law, an employer policy, or an employer practice. Where there is no legal obligation to investigate, you may want to consider if the complaint would constitute a policy violation, right? Because if it does, then perhaps that's grounds for disciplinary action. But before you proceed, you want to make sure that you've done your due diligence and looked into the allegation. It is also best practice to investigate claims of abusive conduct or workplace bullying. Currently, workplace bullying alone may not constitute unlawful employment practice, but it could lead to unlawful harassment down the line. So it is important to take those types of claims seriously. Employers may also have an interest in determining what likely occurred where there is differing facts or disagreements as to some event, or in situations where a subordinate has complained about a supervisor's treatment. Next slide, please. So defining the investigation, after you've decided to conduct an investigation into a complaint, it is time to define the investigation. And there are steps that should be taken to get to that point. So in the next few slides, we'll go over the issues that should be considered before jumping in and starting an investigatory interview. The first is who should investigate the complaint. There are two types of investigators. There is the internal investigators and the external investigators. Internal investigators are individuals like supervisors, designated EEO, compliance officer, coordinators, members of the HR department. External investigators are outside attorney investigators, such as Susan and myself, any licensed PI specializing in investigations. And just so you know, for external investigators, there is a statute called the California Private Investigators Act, which dictates that the external investigator must be either a state licensed private investigator or a state licensed attorney. Next slide, please. And what we have here are 6 essential investigator qualities. These are things to look for when selecting someone to conduct the investigation. Number 1, neutrality; 2, experience; 3, professionalism; 4, availability; 5, excellent writing skills; 6, knowledge of relevant laws. So for example, if someone's alleging they're being harassed, it's important to have someone who understands what that exactly means. And as a bonus, the investigator should have limited prior experience with the complainant and the respondent. The investigator should not be like a supervisor of the complainant or the respondent, should not have any supervisory authority over these parties. And, the investigator should not have a role in any future disciplinary action that may be taken. Next slide, please. There are some advantages of using an external investigator that we do want to talk about. Number 1, in terms of impartiality, an outside investigator will likely be seen as more impartial than an internal investigator. 2, sometimes the scope of an investigation is so large that it would be difficult for an internal investigator to conduct a thorough investigation, along with all the other work that they have on their plate. 3, internal investigators may simply need to delegate investigations to external investigators if they're already handling, several other investigations, and we want to make sure that these investigations are conducted promptly. And four, investigations conducted by external investigators are protected by the attorney-client privilege and attorney work product doctrine, which provides obviously an extra advantage in keeping those types of investigations confidential. But there are some cons, obviously, in going the external route. External investigators will be more expensive than conducting an investigation in-house, because when you conduct it in-house, your investigators are doing it while being paid their regular salary. But if you're conducting an outside investigation, the outside investigator will be charging by the hour. And external investigators may not have the same institutional knowledge that an external investigator would have. So that sometimes may lead to the external investigator taking a little bit more time to get to a certain point where someone who's conducting in-house had already had that knowledge. Next slide, please. So this is one of my favorite area. So once an investigator is selected, it is very important to adequately define the scope of the investigation. I cannot emphasize enough how important it is that there is a mutual understanding between an employer and the investigator about the scope. That means, what are the issues that the investigator will be investigating? Ultimately, it is the employer who decides the scope of the investigation. The investigator may provide input, but again, ultimately it's the employer's call. At times, well, oftentimes, I find issues might come up and it may make sense to expand the scope of the investigation. Again, that is the employer's call. So when I oversee an investigation, which I do very often, I always tell the investigator that they must obtain authority from either my client or from me before expanding the scope. And when I conduct the investigation, I will discuss, sometimes when I approach and get new issues, I always approach my client and let them know of the new issues. I do not investigate those new issues unless I'm specifically directed to do so. And, along with that, we want to be mindful of what they call scope creep. This happens when you are investigating one issue, but the investigation slowly kind of creeps outwards as new issues come up. So it's important to have a clearly defined investigation scope from the get-go. This helps avoid scope creep from happening. Next slide.
Okay, so we have decided that we are going to conduct an investigation. We've defined the scope of the allegations that we will investigate. So next, we're going to talk about how to actually conduct the investigation. Next slide, please. All right, so investigations, they're not one size fits all. I've investigated investigations where there's one complainant, one respondent, 2 allegations, all the way to multiple complainants and respondents, and 17 to 20 allegations. So some investigations are going to be more complex than others, but this slide provides a general overview of the investigation process. We start with the employer reviewing the complaint, next selecting the investigator and determining the scope of the complaint that will be investigated, as Sally just touched on. Next, the investigator will conduct interviews of the complainant, witnesses, and respondent. It's not always necessary to go in that order for interviews, complainant, witnesses, and respondent, but it's the approach I often take. I have seen respondents interviewed earlier on in an investigation where there might be a situation where I thought that the respondent might admit to some of the allegations, because that could sort of streamline the investigation. So different ways to tackle the interview process. Number 4 on this slide, the investigator reviewing documentation and evidence. That's on an ongoing basis. The investigator is going to review information when they first receive notice that they'll be investigating, and then throughout the interview process as they gather more evidence to review. Finally, the investigator will prepare the investigation report summarizing their findings on the allegations that have been made. And usually the investigation report will also summarize the interviews of the different witnesses and the parties to the investigation. Next slide, please. Okay, so the interview process. In most investigations, in most workplace investigations, witness testimony is not obtained under oath. So it'll typically be the investigator and a witness, and sometimes the witness will have a support person or a union rep attend their interview with them. It's really important to provide witnesses the opportunity to tell the investigator whatever it is that they want to tell the investigator about the allegations that have been made. The investigator should strive to develop rapport with the witnesses and maintain an interview environment where witnesses and parties to the investigation feel comfortable providing the information they know about the allegations to the investigator. There's been a debate whether in-person versus Zoom interviews are better. Some investigators feel strongly one way or the other. I do both. If my client or a particular witness or party prefers in person, that's fine. I'll do in person. I would say that probably 90% of my interviews are conducted via Zoom. And I think as long as the witness and the investigator are on the same page in terms of making sure the witness is in a private location, all their technology is working appropriately, a Zoom interview is just as effective as an in-person interview. Next slide, please. Okay, so admonitions. Admonitions are provided to either parties or witnesses at the very beginning of their interview. I typically provide the same admonitions to all witnesses. Sometimes it'll be tweaked a bit if I'm talking to a complainant versus a respondent, and also depending on the type of investigation. There'll be different admonitions that I give for a sworn police officer or a firefighter investigation versus other types of workplace investigations. So what I always do in my admonitions is I'll introduce myself and I'll explain my role in the investigation process. I also explain that what the investigation process looks like in terms of what I'm tasked to do and why they are sitting there. I'll explain that they're a witness, or if they're a respondent, I'll make sure that they understand that they are speaking to me in the position of a subject or a respondent against whom allegations have been made. I record my interviews, I audio record them. And in doing so, I always let my witnesses know that I am recording their interview. I do that before I actually hit the record button, since California is a two-party consent state when it comes to recording. So I usually say to my witness, I audio record all my interviews for note-taking purposes. I'm going to start my recorder now. And then, the witness will say, okay, yes, I understand. And then I'll confirm after I've hit the record button, you understand that I'm recording our discussion, correct? Yes. I also, as part of my admonitions, let the witness know that either the city, the county, whoever their employer is ordering them to maintain the confidentiality of the underlying facts to the investigation. There is a caveat there if they are represented, have union representation, and I'll go over that as well during that part of the admonition process. I also advise my witnesses that they are ordered to cooperate and tell the truth under threat of insubordination. And I let them know that of their employer's anti-retaliation policies and how to report retaliation if they feel that they are subjected to retaliation for participating in the investigation process. The admonitions, I think each investigator has a different way that they approach them. My goal is to provide as much information as I can so the witnesses or the parties to the investigation understand what it is that, why they're sitting talking to me. and the rules that govern the process. But aside from that, the admonitions process is really the first opportunity that the investigator has to develop rapport with the witnesses. So I try to keep that in mind when I'm introducing myself and making sure that the witnesses feel comfortable with the process, because you know, those of us in legal or HR, I think sometimes we've been doing this a long time. We tend to forget that this can be really stressful and an uncertain process for witnesses who may not have the same familiarity that we do. So I think really taking the time to explain ourselves and what's going on goes a long way in building that rapport, which in turn enables the investigator to get the information that they're seeking to get from that witness. Next slide, please. Okay, so I touched on this. So this is all about rapport, striking the right balance when talking to witnesses, you know, making an effort to really connect with the witness, be professional, organized in how you ask the questions that you need to ask, and also be transparent. You know, oftentimes I'll have a witness ask me, well, is anyone going to know what I've said to you? And it's critical for the investigator to be honest. What I would tell a witness that asks me that, I'll say, I'm an external, impartial investigator. Once I conclude my investigation, I'll provide the investigation report to my client, the employer. After that, I'm not involved in what happens to that report. And sometimes I'll get into the fact that there are, you know, a public records request that could occur, which may, you know, result in disclosure of the report. So I let them know that I can't promise them that what they say will not be known to others, but there is a duty of confidentiality attached to the report, to the in the investigation generally, to the extent possible. But transparency is really important. Don't promise something that you can't deliver on, or that might not be the reality of what happens down the road after the investigator is no longer involved in the process. Next slide, please. Okay, so when you go to the interview and you are investigating a witness, really think about who you're talking to. Listening is of critical importance, and it sounds so simple, but it can be a real challenge of really stopping and making sure that you're getting the information and the responses that you need to all of your questions. Interviews are not depositions, right? They should not be adversarial to the extent possible, at least coming from the investigator. The investigator should never take an adversarial approach, but the investigator needs to make sure that they get the information that they need to properly conduct the investigation. So really listen to the answers that a witness is telling you as the investigator, and fill in the gaps. If the witness gave you some statements, but they don't directly give you the who, what, when, where, why that you need, follow up. Say, well, who said that? When did you hear that? Those sorts of follow-up questions are really important. And flexibility is really important as well. There is a goal of getting the information that the investigator needs, but it's also important that the discussion between the witness and the investigator be conversational to the extent possible. So if a witness is giving a narrative response and really opening up and kind of spilling their guts to the investigator, that might not be the right time to interrupt and say, well, give me the who, what, when, where of what you're telling me. You might want to just kind of hold back and be flexible and wait till that witness is done giving their statement, and then follow up after the fact. So again, organization, having an interview plan, flexibility, really listening to the witness is critically important in order for that investigator to get the information that they need. Next slide, please. So we touched on this. Again, I think remote interviews are just as effective as in-person interviews. You want to make sure, though, that your location is as distraction-free as possible. I have had a cat appear in my background before, which kind of added some levity to the interview, but again, it's a distraction. So try to make sure that you don't have anyone in your office space or any pets in your office space that can, distract from the work you need to do. Try to maintain eye contact on Zoom. That really helps connect with the witness and building that rapport that we've talked about. As part of the admonitions process, when I'm conducting a remote interview, I always let the witness know that no one else is in the room with me. If that's true, and it should be true, you should not have anyone in your office with you if you're conducting a remote interview, unless you tell the witness that someone else is in the room with you. And again, I have sort of a war story. I was interviewing a witness once on a remote interview. I did not set up the interview, but very early on during the admonitions process, I realized that the witness was in an open cubicle. There were other coworkers around the witness, and come to find out after the fact, the respondent was sitting in the next cubicle over from the witness that I was interviewing. I immediately, once I realized this witness was not in a private location, I stopped the interview, and we reconvened at a later time. So, privacy is important because we're talking about confidential workplace issues. Next slide, please. Okay, so we just touched on this. So confidentiality. There is an AWI guiding principle that states that the investigator should maintain the investigation file in a manner that will protect the confidentiality of the information contained therein. That goes for external investigators, but internal investigators as well. On the flip side, the investigator should make sure that the complainant understands that complete confidentiality is not guaranteed in a workplace investigation. And I'll give you an example of this. So during the interview process, it's quite possible that the complainant's name or other identifying information may be referenced in order to question witnesses or the respondent about the complainant's allegations. Thus, it's highly likely that witnesses and the respondent may be able to figure out the identity of the complainant, right? So again, I might, as an investigator, I might not specifically identify to anyone that I'm interviewing who the complainant is, but it's typically fairly easy for folks to figure out who's making the complaint. What you can let a complainant or a witness or a respondent know is that the goal is to confine the details of the investigation to those on a need-to-know basis. But again, it's important to be transparent and remind anyone that you're speaking to that total confidentiality is not guaranteed in a workplace investigation. Next slide, please.
All right, so credibility, making the determination. So every investigation requires a credibility assessment of some kind. It is very likely that you will get conflicting statements from parties in an investigation. Sometimes I, get a he said, she said situation. That doesn't mean that the investigation stops then and I make an inconclusive finding. That means that I need to determine, are those statements essential to the findings? And if so, then I need to make a credibility determination, meaning which statement do I believe is more believable? Investigators have an obligation to be deliberate, systematic, and objective when determining witness credibility. It is completely fine to have a difficult time making credibility determinations. I find that this is probably one of the most difficult time in an investigation in determining like which statements do I find more believable. So there are some credibility factors, which we'll discuss in the next slide to help you with that assessment. I personally enjoy making credibility assessments. It does force me as an investigator to closely examine all of the evidence that I've obtained in the investigation. You know, and in the investigation, you've requested documents, you've done a bunch of statements, and now this is the time to really weigh the evidence. It's your time to determine if there are any gaps in your investigation. Do you need to conduct follow-up interviews? Do you need additional documents that will help you in determining which statement that you find more believable, and ultimately make a decision if you can? I mean, there are certain circumstances where their evidence is just insufficient to make a finding, but in most cases, you should really try to make a decision as to whether or not something's sustained, not sustained, substantiated, not substantiated. Again, credibility has to do with determining whether someone's statement is believable or not. As an investigator, you are not trying to figure out if someone is lying. Next slide, please. So in terms of credibility, we use objective factors when determining credibility. And the accepted credibility factors are listed here. We have inherent plausibility. That means, is the statement believable on its face? Does it make sense? There's motive to lie. Does the person have a reason to lie? Does the person have a bias, an interest, other motive? Corroboration. Is the witness or party's testimony or physical evidence that corroborates someone else's statements or testimony? Did the party contemporaneously document or report the incident? Like, what evidence do you have to corroborate the statements? Ability to perceive, you know, sometimes you have witnesses who say that something happened, but when you ask them questions, you actually realize that they may not actually have actual knowledge. They never had the opportunity to perceive what they're making statements about. So you definitely want to make sure that you get that clarification. And then there's reputation for honesty and dishonesty and habit consistency. Is there evidence that is consistent with the person's statements, or perhaps did the person make inconsistent statements during the investigation? So when possible, try to rely on more than one credibility factor when making a credibility determination. Factors that investigators should proceed with caution or not at all are listed here as past record. Means, does the person have a history or similar behavior or relevant history? Reputation, does the person have a reputation of engaging in similar behavior? Attitude, did the person cooperate when participating in the interview or providing information? And demeanor, did the person seem to be telling the truth or lying? The reason why we kind of proceed with this with caution is because there could be other factors at play. I mean, investigations and being interviewed and a party in an investigation is a scary process. And sometimes they don't want to be there and they don't want to participate. So, you know, I don't look into how their attitude or demeanor at an interview to determine whether or not they're credible, because I understand that there are other factors at play. Next slide, please. And then once you have all your information, you want to write the report. I start writing my report during the investigation, like very early on, just at least have some sort of framework, and then I continue to update it along the way. When it comes to a report, you want to have a thorough investigation report, and those investigation reports should include these components. You want to spell out your investigation process, what the scope of the investigation is, the documents that you reviewed, summary of the relevant background information, a complainant's, what was the allegation, what is the respondent's response to those allegations, what did the witnesses say, and then what are your findings? And if you made any credibility determination, you want to really put into detail what that is. That would help you down the line if you're, have to testify at a deposition or at trial. This will help you recall information and then help you also understand why you made, the findings that you did. Ready? Next step, please. Slide. So writing the report, in making investigation findings, we use the preponderance of the evidence standard. What that means is, what is more likely than not that occurred? So you want to weigh the evidence, which side, and determine which side outweighs or is more than the evidence on the other side. And then ultimately, you want to make findings. And the typical Standards are, you make an unfounded finding, or unsubstantiated or not unsubstantiated. Sometimes investigators use the term sustain or not sustain. And then there's exonerated. Typically that's in connection with the policy violation, and then inconclusive. Next slide.
All right, so next we're going to talk about top investigation mistakes. And we're going to talk about 5 of them. And these are questions that we get, the top 5 questions that we get when we provide workplace investigation training like this. So hopefully these next slides will help answer some of the questions that you might have. Next slide, please. Okay, so investigation mistake number 1, not following up on details with witnesses. Examples, someone says that the respondent messed with everyone all the time. All right, well, what does messed with mean to that witness? It might mean something different to that witness than it does to the investigator, to someone else. Who is everyone, right? Is it every single person in the office? Is it one person in the office? We need to figure out what that witness says when they say everyone. And also, what does all the time mean? Respondent messed with everyone all the time, right? We need to get more details in terms of what that witness meant by that term. It's very common for witnesses to attribute different meanings to terms than the investigator or than someone else. So it's really important if you're unsure. Let's say a witness is using a term that you're unsure of, what they mean by it. Ask them. Say, well, what do you mean by, whatever it is, the term that they are using? Next slide, please. Okay, so investigation mistake number 2, failure to interview relevant witnesses. So we're talking about a judgment call in terms of who the investigator decides to interview. Obviously, the complainant and the respondent are going to be interviewed. I tend to ask, I tend to interview eyewitnesses to the extent that they're available to be interviewed. Those are important. I also tend to interview witnesses that have been suggested by the complainant and the respondent of witnesses that they think I should speak with. That's always a question that I ask at the end of every interview. Who else do you think I should talk to in connection with this investigation? And I ask it of every witness and the complainant and the respondent. Does that mean that I interview every single witness that's identified by the complainant or the respondent or witness? No, I have to use my judgment, and I have to balance thoroughness with efficiency because it's expensive and it's time consuming. And it's typically unnecessary for me to interview every single person in the office in connection with an investigation. So good judgment is key in terms of who is being interviewed. But I will caution, if you interview everyone that the complainant suggests that you interview, and you don't interview anyone that the respondent has suggested that you interview, that can be a problem if the investigation is ever attacked through litigation or otherwise. Next slide, please. Okay, top investigation mistake number 3, a refusal to interview former employees or third parties. I've had a number of clients that have a practice of not allowing interviews of any former employees to their organization. And that has included in one circumstance, a complainant who voiced a complaint and then quit. I wanted to interview that complainant, but the client said, no, we don't want to. We have a policy of not interviewing former employees for investigations. And their reasoning was essentially they didn't want to poke the bear. And they thought that if they interviewed this former employee, that might motivate that employee to file a lawsuit. I want to caution against that kind of practice. Do not let the fear of litigation taint the investigation. Obviously, interviewing that complainant would have been really important. And if I was ever attacked on the stand about my investigation, I'd be testifying under oath, and I'd have to explain that I wasn't given the opportunity to investigate or to interview that complainant. So that doesn't put the investigator in a good position. Aside from complainants that are former employees, witnesses that are former employees can make excellent witnesses. If you think about it, they have a more limited motive to lie, right? Their job isn't on the line. They no longer work in that workplace. And those can make very, very good witnesses because oftentimes they're very open and honest in terms of the type of information that they'll provide the investigator. Okay, next slide, please. All right, so this is probably the number one question that we get. How do you make a finding when the evidence is he said, she said, or one word against the other word, right? This is how most investigations are, right? That's why we're investigating, because there's a question of fact. Did this person say this to this other person? Did they do this to another person? If we already knew if the conduct was already admitted to, then there's usually less of a need to investigate if everyone agrees on what happened, right? So many, if not most, investigations are going to require a judgment or a credibility call. Again, as Sally mentioned, credibility. This is when you use the credibility factors. When you have witnesses on one hand saying something occurred, and then you have witnesses on the other hand saying, nope, that did not occur. That's when we use our credibility factors to determine which witnesses or whose statements we're going to believe. And this is the investigator's purpose. This is why the investigator has been asked to investigate, is making findings on the allegations that have been alleged. So if you're ever stuck in one of these situations and you don't know how to make a finding, rely on your credibility factors and seek more evidence, right? Interview more people if you need to. Next slide, please. All right, so last top investigation mistake is not providing the respondent the opportunity to respond to all the allegations against them. And a respondent has the right to respond to all the allegations against them. Do not hide the ball. Make sure that you are covering each and every allegation with that respondent, even if the allegations are uncomfortable and you don't necessarily want to have a conversation about the allegation. You have to. When you're interviewing that respondent, you have to allow that respondent the opportunity to respond and give you their side of the story in response to each allegation against them. Next slide, please.
So post-investigation matters. This has to do with what typically happens after the investigation has concluded. Next slide, please. So if the investigation sustained that wrongdoing occurred, an employer should take action. And the reason for that is you want to prevent similar misconduct from taking place. You want it to serve as a discipline towards the wrongdoer, and also send a message that the employer will not tolerate misconduct in the workplace. And that's also kind of the reason why you conducted the investigation in the first place, to find out if there was wrongdoing. And ultimately, the appropriate level of discipline will depend on the egregiousness of the conduct. So it's really hard to say. And oftentimes, clients may work with their counsel, or maybe they might determine that in-house of what the appropriate level of conduct is. It is important that whatever disciplinary action is taken, it is consistent with policies and procedures, as well as how you've disciplined employees in the past. Basically, you don't want to treat someone more harshly or less harshly, because that could then be grounds for or a reason for someone to bring a discrimination claim. Also, it's important to review your policies, employers' policies. Some employers have specific policies and notices that must be provided to the complainant, the respondent, and sometimes to witnesses. So you want to make sure you understand what the policy provides, what the investigation procedure states and that you follow that process. Next slide, please. And after receiving the final report, it is a decision maker who needs to review it along with the supporting documents. Sometimes an employer may request changes to the investigation report, non-substantive changes such as, fixing any typos or misspellings, that's okay. If there's areas that you would like clarification, that's definitely also okay to request. It's also okay to request that the investigator conduct additional follow-up if you feel like you need additional information so that you can then issue some sort of disciplinary action. What is not okay, however, is asking the investigator to change their findings. That would certainly impact the independence and the neutrality, and as well as the integrity of the investigation, which will be problematic down the line. Next slide. And then disclosure of the report. I saw some of the questions in the Q&A, and I think some people have questions about this. So an employer does have a legal obligation in some circumstances to disclose the investigation report. This is regardless of whether or not the report or the investigation was conducted by an attorney investigator. So as many of you probably know, most public employees have a protected property interest in continued employment. So under Skelly versus State Personnel Board, these employees must be afforded, employees that you discipline must be afforded with a pre-disciplinary action process, which provides them with a notice of intent to discipline, also known as the Skelly notice, and then access to materials upon which the proposed discipline is based. So if an investigation report was relied on for the proposed discipline, it must be provided to that employee. Under POBAR, peace officers must be provided with notice and an opportunity to respond to adverse comments in the personnel file. So in those situations as well as the Skelly rights, again, also are provided with a copy of the investigation report, regardless of whether or not an attorney had conducted the investigation. And in a 2011 PERB case, the city of Reading, the city was ordered to produce an investigation report and witness statements subject to redaction of all employee names and identifying information, where the union asserted that access to the information, the report, was necessary in order for them to represent their members in being free from a hostile work environment and to work in a safe workplace. And at times, there are PRA requests that may be made, or a union may make some informational requests, and that may result in the disclosure of an investigation report. So for that reason, it is important that employers and investigators do not promise complete confidentiality in any investigation, because you just never know when it has to be disclosed. Next slide. So that is the end of our presentation. And any questions for Susan or I?
Perfect. Thank you so much. Yes, so we do have a few questions that have come in, so we'll get through as many of these as we can in the next 5 minutes or so. And then if we don't get to your question, I apologize, and we will definitely let you know how to follow up as well. So I've seen quite a few questions come in around the recording component as you were talking about the interviews. So is there any advice, or is it acceptable for folks to refuse to be recorded when they're interviewed?
Sally, you want me to take this one?
Sure.
So I can count on one hand the number of times a witness, or it's usually a witness, has refused to allow me to record. When that happens, I will end the interview, or at least pause it and get in contact with my client and let them know the situation and ask my client how they want to proceed. And the reason for that is when I record everyone, right? I don't pick and choose which witnesses I record, because that could be problematic down the line if the investigation's ever attacked. So yes, it's possible that you're going to have witnesses that refuse to be recorded. Since I'm external, I don't know really what goes on behind the scenes between my client's HR and the witness who's refusing to be recorded. But I've had situations where the witness changes their mind and then they allow me to record them. I've also had situations where the client said, this witness will refuse to be recorded, but we still want you to interview them. And I just note in my my investigation report that this witness refused to be recorded. And I have to take copious amounts of notes when a witness refuses to be recorded.
Perfect.
And
Thank you.
to add, just want to add to that, and in situations where you don't have a recorder, you can always have someone else sit in the investigation and just help with the note taking to ensure that you've captured everything that was stated at the interview.
Great. Also related to the recording component, do you have any recommendations on apps or things like that that you use to do that type of thing? I know you mentioned Zooms, or do you just use the Zoom recording component? Is there any recommendations on recording software?
For me, I use if I'm interviewing someone in person, I just use a regular recorder and I upload the file. And if I interview someone by Zoom and I record them, Zoom does provide a kind of a transcript, but the transcript is so off, so I never rely on that transcript. But it's helpful to go when you go through the recording to kind of play along, and things kind of go through more quickly, but it's very inaccurate.
Yeah, I don't know if you can see it. No, you can't. I have a little, this might be what Sally is. I use the same thing. It's old school.
That doesn't mean it's bad, right?
No, exactly. That's why I use it.
Perfect. There's also some questions related to timelines. So is there any explicit timeline for completion for investigations? Is there a good rule of thumb there? Or does it really depend on the type of investigation?
So I guess I can start with that. It depends. You want to conduct, if it's a complaint regarding harassment or discrimination or retaliation, there is a duty to conduct a prompt and thorough investigation. So in those situations, you do want to try to do it as quickly as possible. I understand in some situations, there may be a delay to explain there may be something that comes up and it's reasonable to delay it a little bit, but there should always be an explanation as to why certain investigations take so long. For peace officers under POBAR, there is a 1 year time frame at stake. Once the employer knows of the conduct, you do have 1 year from that date to issue any disciplinary action. So that there is some sort of a deadline there with peace officers. Susan, anything else to add?
No, I think you summed it up perfectly. I mean, it can be very difficult in the interview phase to coordinate and schedule the witness interviews, and that can delay an investigation. I think kind of a rule of thumb is if you have an investigator who's letting you know, I can't get started on this for another month, you might want to pick another investigator, because you really need to try to get the investigation done as quickly as you can within reason.
Thank you for that. Let's see here. We have quite a few more questions. Let me see if we can get maybe one more in here. Another kind of process question, is there any particular order that you interview witnesses in? Do you start with the complainant or the respondent? Is there any kind of good rule of thumb there for folks?
I guess I can start first. I know Susan touched upon this at one of the slides, but I usually like to start off with the complainant, because sometimes we have a written complaint or an oral complaint or some notes that maybe an HR personnel had taken. So I want to understand what exactly is the issue, what are they complaining, who's the respondent, get all that clarified, and then go back to the client and have them confirm the scope of the investigation and then proceed that route. And I typically interview respondents last, but there are situations where it may make sense to interview the respondent earlier on. I have a few investigations now where basically I had to interview the respondent first. So it's a case-by-case basis, but typically my order is complainant, witnesses, and then respondents, and then maybe follow-up interviews if needed.
Susan, anything you want to add to that?
No, Sally summed it up perfectly. That's my practice too.
Perfect. Okay, so we are at time, and I just want to acknowledge to the attendees. I know we have a lot more questions that we didn't get to. There's a lot of content to get through, so appreciate your patience with us. And I will share contact information in just a second if you want to follow up with us offline. But before I get there, just want to do a quick plug for our ILG resources again. So if you again aren't familiar with us or aren't connected to us, here's our social media channels as well as our newsletter information. So this is a good way to stay on top of additional trainings or resources that we put out. A quick reminder that we will be sharing the slide deck as well as the recording as soon as possible. So probably by the end of this week, we will get that out to you all. And then here is our contact information. So again, I'll pause here for folks to take that down if they need to. And again, we'll share this out with everybody. But just also want to give Sally and Susan, if you have any final thoughts you want to share before we sign off.
I just want to thank everyone for participating. We have I was looking at Q&A. We have a ton of good questions. So I'm so happy that you are paying attention and find this topic interesting.
Yeah, thank you so much for hosting us. Sally and I could probably talk for hours about investigations. It's something that we love doing. So we're just really thrilled to be able to share what we do with everyone.
Yeah, I think we could have had a whole day training on just this topic, it seems like. So I want to thank everybody on the line for joining us over their lunch hour as well. And a big thank you to Susan and Sally for sharing your expertise with us. And I hope everybody has a fantastic rest of their afternoon.
Thank you, everyone.
Thank you.